In recent days, Parliament has opened a public call for submissions to the Ad Hoc Committee that is probing serious claims made by Lieutenant General Nhlanhla Mkhwanazi about the SAPS leadership. The committee wants anyone with information to come forward before the deadline of October 17, 2025. This invitation has stirred both hope and worry across the country. Some people see it as a real chance for truth and accountability. Others fear that important evidence will be ignored or be ruled inadmissible when it matters most. To understand why this moment is so important, we need to remember the background. In July 2025, Lieutenant General Mkhwanazi made public allegations of interference in investigations, irregular contract awards, and other wrongdoing linked to senior police and outside actors. These claims were dramatic because they named powerful people and suggested that parts of the criminal justice system could be compromised. The president then appointed the Nhlanhla Commission to look into those claims, and Parliament set up its own ad hoc committee to run a parallel inquiry and to gather evidence from the public. Both processes aim to answer deep questions about how police conduct and governance affect public trust. The public call for submissions matters for two reasons. First, it gives ordinary people a formal way to hand over documents, witness statements, or tips that might otherwise stay private. Second, it raises the critical question of admissibility. People rightly ask, will the committee accept evidence collected by citizens? Will screenshots, WhatsApp chats, or informal recordings be treated as proof or dismissed as hearsay? The committee has set channels for submissions, including an email address and a hotline, but the rules about what counts as acceptable evidence are shaped by both parliamentary procedure and legal standards. That tension is at the heart of public concern. We should be clear about how evidence usually gets treated in such inquiries. Parliamentary committees can collect, examine, and publish evidence. They can also invite witnesses to testify under oath. But Parliament is not a court. Its findings may lead to criminal investigations or prosecutions. But courts require verified chains of custody, forensic checks, and testimony that meets legal standards. Screenshots and leaked chats can prompt probes, but on their own they may not hold up in court without proper verification. This is why many legal experts call for people who submit material to preserve original files, metadata, and witness contact details. If this work is not done, promising leads risk being dismissed later. At the same time, there is a political dimension that cannot be ignored. The Ad Hoc Committee operates in a charged environment. Parties will push their own agendas, and MPs may use hearings to score points ahead of future elections. Some commentators fear that partisan interests could overshadow the search for truth. Others argue that political pressure can force institutions to act when they might otherwise delay. For citizens, the worry is practical. Will the committee treat submissions fairly, or will some testimonies be amplified while others are sidelined because of who they implicate? Past episodes in South Africa show both risks and opportunities when Parliament takes up sensitive matters. So how should someone with potential evidence proceed? First, document everything carefully. Keep original files, note dates and times, and save any digital metadata. Second, consider legal advice or contact civil society organizations that help whistleblowers. Groups that specialize in anti-corruption and witness protection can advise on how to hand material to Parliament or to law enforcement while reducing personal risk. Third, use the formal submission channels provided by the committee and keep copies of what you send. Submitting evidence publicly or through media can draw attention, but it can also expose the material to claims of tampering. The safest path is to combine public pressure with careful preservation of originals. What about the committee's duty to act on submissions? The Ad Hoc Committee should have clear procedures to screen material, verify authenticity, and protect witnesses. Ideally, it will pass credible leads to independent investigators or prosecutors for forensic work. It should also publish a roadmap showing how it will handle received materials and what standards it will apply. Transparency in process builds public confidence. If the committee makes decisions behind closed doors or treats key submissions as political theater, public trust will suffer and the opportunity for real accountability could be lost. Civil society and the media must therefore watch closely and press for clarity about how submissions are processed. There are difficult trade-offs. Releasing all evidence publicly may help transparency, but could also tip off suspects, endanger witnesses, or compromise ongoing investigations. Keeping everything secret can protect the process but breed suspicion. A balanced approach is possible. The committee can publish summaries and procedural updates while referring sensitive materials to independent investigators with the tools to verify and, if necessary, to prosecute. This hybrid path demands discipline and independence from both the committee and enforcement agencies. It will also require Parliament to resist political pressure that seeks to shape outcomes for party advantage. Looking ahead, several scenarios are possible. The best outcome is that citizens submit well-documented evidence, that the committee screens and routes credible leads to investigators, and that the Nhlanhla Commission and prosecutors follow up with forensic checks. This would produce a clear public record and, where warranted, prosecutions or institutional reforms. A less positive path is one where evidence is scattered across social media, where verification is weak, and where partisan clashes prevent a focused inquiry. In that case, the moment could pass without structural change, and public faith and oversight would be weakened. A middle path, partial verification, selective action, and incremental reform, is perhaps the most likely unless strong civil society and media pressure push for fuller accountability. For viewers who consider sending material, remember the risks and responsibilities. Honest whistleblowing helps democracy, but sloppy evidence can harm legitimate cases and hurt innocent people. If you have sensitive documents, seek counsel on how to submit them securely. If you plan to make public claims, be ready to have your evidence tested. The public interest is served best when truth is established through careful work, not by loud but unverified headlines. Before we end, tell us what you think. Will the Ad Hoc Committee handle submissions fairly, or will politics get in the way? Do you have concerns about whistleblower protection or evidence admissibility? Share your thoughts in the comments and tell us what follow-up reporting you want. If this video helped you understand the process, please like, subscribe, and click the bell so you do not miss future updates. We will keep watching this story and bring careful coverage as it unfolds. Thank you for watching and for taking part in the conversation.